Okay, our third and final case this morning is Grove Isle at Vero Beach Condominium Association versus Universal Property and Casualty Insurance Company, number 2024-0764. Whenever you're ready.
May it please the court. I'm Debbie Macon with Lydecker LLP here on behalf of the appellant Grove Isles Condominium Association. Two members of the 4th District got it wrong. They failed to recognize...
I apologize. I'm having a little trouble hearing you.
Okay. Two members of the 4th District got it wrong. They failed to recognize that this amendment was only prospectively applied. Just 2 months later, the 2nd District Court of Appeals, with the benefit of the 4th's opinion, decided to rule the exact opposite way on parallel facts. That's the Laguna Rivera decision. There's a reason the 2nd District found that 627.714 sub 4 was only prospectively applied. The amendment here attaches consequences to events that took place after the effective date of the statute, which is July 1, 2021. Hence, there's no concerns with retroactive application. Now, you may be saying, doesn't this insurance contract exist before July 1, 2021? So just because certain events predate the effective date of a statute, such as the incepting of a policy, does not mean there was retroactive application.
What are the relevant, is the relevant event then, your position, is the accrual of the cause of action, that there are certain contractual rights that don't vest until the accrual of the cause of action, right?
Yes.
Okay, now help us understand. That would seem, if we take that principle to its logical extent, to include just about any contractual promise that depends on future performance. Where would you draw the line? And perhaps it's easier to draw in the insurance context because we need some sort of loss. But help us do that, because obviously all contracts, I shouldn't say all, most contracts are forward-looking in some sense. They require performance, and so there will be some expectation. And it would seem to me that we'd have to have some way to say these expectations, while perhaps not fully realized, are nonetheless subject to some, protection. Indeed, the Constitution says so, right? We have a whole line of cases about, not interfering with the obligations of contract, and that significantly doesn't speak to just terms of contract. It says obligations of contract, which means that the constitutional protection also attaches to certain forward-looking things, the performance of obligations. Can you help us draw that line?
So the way the courts, Florida courts, have traditionally followed this approach is they've looked at what is the right that we are talking about. They've had to evaluate the nature and quality of that right. And so that gets us right back into, are we looking at this contract and researching for vested rights? And did subrogation meet that quality? And there are many tests here. We can go back to Knowles. We could go to Justice Kennedy's decision in RAM when he was with the 2nd DCA, and it failed the test of vestedness.
Is what matters the fact that subrogation is as to a party alien to the contract? Like, help me understand what makes subrogation different.
So if we were going to look at an insurance contract and we're going to say, what is the benefit of the bargain? What's the purpose of this contract? Well, let's look at the primary. We want to make sure someone has coverage in their time of trouble. We want to make sure the insurer is paid. But who the insurer gets to sue on the back end, that's really an ancillary thing to the contract. Even the dissent in Grove Isles recognized this, that when this policy is incepting, whom they're going to get to sue, when they're going to sue, what is the actual event of loss, all of these things are completely I'm sorry.
Sorry, no, go ahead. Can I just ask you about why it's a cause of action versus contractual? So I think the 2nd DCA's position is that nobody has an interest in a cause of action. I think your argument now, if I understand it correctly, is that the right was not in the cause of action. There might be interest in what's policy language. But under this statutory change, a condo owner can still sue an association, right? There's still the cause of action is still live between the unit owner and the association. What's limited by the statute is what can go into an insurance policy. So why should we be looking at it through the lens of cause of action is yet to accrue versus what the statute appears to do, which is say an insurance policy cannot contain this language?
So it says it may not be enforced. What it is it's a conditional immunity, okay? And what Universal wants to say is, before we used to be able to sue everyone and their mother. Well, they can still sue everyone. The list of targets is still extremely long, okay? Mother may be off the table, and the reason I say may is it's conditional. Mother, being the association, is going to have to meet certain predicates before they even qualify for the immunity. So this is a third party that is well beyond this contract that is enjoying a qualified immunity. And it is enjoying immunity to something that really didn't even exist before July 1, 2021.
I think but I mean, I think the question though is your character. I mean, part of this, it seems like a lot of the case comes down to framing. You know, you're characterizing the statute as if it's giving an immunity. I think another way to look at it is that the statute, the way it's written, is essentially regulating the contents of insurance policies. I think if you view it the latter way, which I think was the premise of the question, then really you don't even get to any of this vested right and when did things accrue and whatever, because if the statute is written in a way that it's basically saying this is what insurance policies may and may not contain, then at sort of step one, the first question that the court would ask is, has the legislature clearly expressed a desire to regulate already existing policy contracts? And here I think the answer to that would be no, and so the case is over. We don't need to get into any of this other stuff, which I think is the way the fourth TCA viewed it. And so I guess I think to respond, to kind of explain what's wrong with the fourth TCA and to answer the question, I mean, I think that's the point. The statute doesn't say from henceforth, you know, after the effective date, such and such is immune from such and such. That would be kind of a different thing. We'd be asking whether the granting of that immunity took some right away that was vested or whatever. But the form of the statute, rather than being written that way, it was written to directly regulate the content of the policies. Why then do we not sort of at step one then look for the clear intent to apply that to already existing policies?
So the way it is written is it says you may not provide for a right of subrogation against a condominium.
But you left off the beginning. What's the beginning?
An insurance policy issued to an may not provide.
Okay. So I mean, so explain why that isn't applying to insurance policies issued after the effective date of the statute.
So it is being applied on a conditional basis, okay? It is not invalidating subrogation clauses in policies, okay? Those subrogation
Well, it's invalidating it to a certain extent. Under certain conditions, it's a partial invalidation of those provisions in existing policy. That's how you win, okay? Right?
It's saying that they can have effect, but this entity, which is outside of this contract, they have a defense if they gave up something, okay? That's really what it is saying. And the reason it is really not going back and rewriting these policies, again, legislatures, they are presumed to know what the law is, okay? They know going in, once they put in this effective date, they are not supposed to be tinkering with vested fundamental substantive rights. What they're saying is, because this is in a way subrogation, it doesn't exist.
Isn't there just kind of, and this is a very complicated area, and I think both of you did a good job briefing it, and it's extraordinarily complicated, and you kind of, the way framing things is critical. But isn't there just kind of, and this is just following up on what the chief has already said, but isn't there something out there kind of in the atmosphere in this arena that if the legislature is going to go messing with contracts, a category of contracts, even just messing with them a little bit, that they need to make clear that they're doing that not just prospectively, but as to existing contracts. And that's kind of swirling around this. That's what the fourth DCA basically, I think, is what led them to where they got to, that threshold question about what the legislature means. But it's particularly an issue when we're talking about things that are in contracts, because the idea is that ordinarily if you got a contract, you got a contract. and you're good. And the government's not going to come in and say, oh, well, you can't do that. That part of the contract's no longer any good. Now, I'm not saying that they can't occasionally do that, and that's always improper. But the presumption is that that's not going to happen unless the legislature says, yeah, we're coming in, we don't like those existing contracts, and we think it's against public policy and it causes all these harms, and we're going to undertake a regulatory measure to stop that. But that is not the way this is framed. This is focused on, as the chief said, it's focused on contracts, not so much as a regulatory matter about contracts. Do you see what I'm saying?
I do see what you're saying, but they have left subrogation intact. Let's look at the entire universe. They can still sue roofers. They can sue pipe fitters. They can sue the fire and sprinkler people. These are likely listed.
Well, I understand that might be a very powerful reason to say that they could do what they've done if they clearly made it applicable to existing contracts, as opposed to policies issued after the law came into effect. But I don't see how that point that you're making has anything to do with what I was talking about or what the chief was talking about.
I think the issue you may be trying to get at is any impairment possibly tolerated. That's, are we? Is
No,
that,
I don't think
no?
we're
I think
okay.
maybe
Well,
I can.
I'll suspend.
Could I just say, this is going to be a very simple kind of question, but I think it's kind of going off of what they're saying is, I'm having, what is your best argument that this is not simply a statute regulating insurance policies? And what can the language of insurance, what can be in an insurance policy and what cannot? Because it seems like your argument is focused on this is regulating subrogation. I don't know that I view this as regulating subrogation. I view this as regulating insurance policies, just period. And we generally said if the legislature does that, it's anything after that date, unless they make an intention to be before that. So that's kind of a very straightforward version, I think, of what they're saying is that why is this just not a general insurance policies shall not have this, they shall have this, and it moves forward?
Because I see this as an immunity at the end of the day, that part is not going to be enforceable for this particular defendant.
In insurance policies, in the language of the insurance policy.
For associations, this is not going to be enforceable against them.
I think if I were to try restating what you're saying, tell me if I mess this up. One way to look at this is the chief is right. This is about regulating the content of an insurance policy. But our job in determining the retroactive effect of things, as we said in Metro-Dade County versus Chase, is the court, quote, the court must ask whether the new statutory provision attaches new legal consequences to events completed before its enactment. A policy is not an event, okay? The retroactive assessment is about happenings. It's about facts on the ground, not the terms of the policy. And here, the relevant event is the loss, is the accrual of the cause of action. Am I understanding this to be your argument?
It is, because until we have that, we don't know if this insurance policy is even obligated in any way to pay for that. And that critical event doesn't happen until after the effective date of the statute. And that's exactly why it's not being retrospectively applied, okay? One of the things that Landgraf said is that just because you're upsetting prior expectations of the law, it doesn't mean that the law is being applied retroactively. And here, what I feel that the Fourth did wrong was it just kind of went ahead and gave it retrospective effect. But in Devon, Chase, all of those cases, it says it's a rule of construction that a statute is not going to be given retrospective effect unless its terms clearly show that such an effect was intended.
Do you think this could vary policy to policy depending on the language? Because the policy here, if I have it right, and I find it interesting that neither court discussed it, but if I understand the policy language correct, it's that it says, if we make a payment under this policy and the person to or for whom payment was made has a right to recover damages from another, we shall be subrogated to the right. So that's it's almost a contingent subrogation. If they have the right to recover, we get to recover. So conceivably that right could change over the course of the policy, depending on the legislature's policy decisions. If a policy explicitly said we have the right to recover against your condo association in the event of a loss, would that be a different case in your mind, or is this kind of a blanket rule regardless of policy language?
I think it really doesn't matter in a way what the language is exactly. I think it is that associations, they are recalibrating the relationship here. Okay, remember before 2010, they were basically prohibited. Here, they don't go back and say, we're just getting rid of subrogation clauses. They could have done that. They could have even said, we want to do it retroactively. They don't do that. So when they don't say that, we basically stop at the first prong, and we're not supposed to give it retro. We're supposed to be asking, can this thing, there's this presumption towards prospective application. And to me, this gets back to, we have a rule of vestedness here. We have applied it to every single litigant where we have actually looked at the cause of action. We've looked at the nature and quality of the thing taken away, and there shouldn't be a different standard here for insurance companies. I think that one of the things here is something the legislature has done. I do think we need to look at what is within the powers of the legislature here, okay? And they didn't touch upon a vested right, and that is one of the reasons that this thing can be applied after July 1, 2021 without having retrospective. And it is well within their legislative prerogative to create prospective defenses or immunities for third parties, especially where we are dealing with an unaccrued common law tort that may or may not happen. So this court has said, causes of action, they're like species of property. But the legislature remains free to create substantive defenses and immunities for use in adjudication. That's Clause L. That's Old Port Cove.
But that doesn't mean that we presume that the legislature intends to write existing contracts. That's a different, and again, this is why it's so complicated, but I go back to what the chief and I said earlier. We've got this thing about contracts. There's something, that's a special thing. And whether your right to damages may have your right to a particular performance or something like that has actually matured under the contract, that you've still got a contract. And the legislature typically, we understand that the legislature doesn't go messing with contracts unless they're very clear about it.
Exactly.
Because we do kind of think contracts are not absolutely sacrosanct, but they are something that should be protected.
Yes.
Or certainly from inadvertent interference by the legislature.
Yes, and our point is they're really not messing with the contract in a sense. They are basically saying for this association.
Counsel there would disagree.
In the face of the statute, that's the thing. The legislature had many different ways to skin this cat. They could have written in terms of immunity, so-and-so has immunity from this point forward. From this point forward, so-and-so can't sue so-and-so, whatever. They did not choose to do that. They chose to write a law that expressly says this is what can and cannot be in a contract. So before you even get into the power analysis, the first threshold question is, what did the legislature do in this law? Before we start asking, did they have the authority to do what they did? And at the step of asking what did they do, they chose to regulate contracts. When the legislature does that, we have our standard tests for, okay, well, did you intend, quote unquote, to be regulating existing contracts? Yes or no? Seems like the obvious answer here, if you believe that that's the right way of looking at it, is no. Case closed. Why is that wrong?
Because in the future, laws are meant to be future written, okay? They are basically telling them, do not write your policies this way. This is one association that will have a defense if they have given up this right. And here I'm sorry.
Go ahead. No, go ahead.
Okay, the critical event, okay, we are talking about is you have to have an event of loss before subrogation as a concept can accrue. That doesn't happen until after the statute goes into effect. This is exactly why the Second District Court of Appeals said.
Okay, Justice Cordell has a question. 'cause your
I'm
time's
sorry, I don't want
almost
to.
up.
I don't want to eat into your time. What if it went to coverage instead of subrogation? What if, let's say the policy is against earthquake loss, and the Florida and it's for $1 million worth of coverage, and I've been paying premiums. Let's say I've paid $100,000 worth of premiums. Okay, and the Florida legislature passes a law that says no payout in an earthquake shall ever exceed $500,000. Cannot that at that point I haven't suffered a loss. Okay, legislature passes the law, I suffer a loss, and now my coverage is restricted or not?
So in that example, yes, there's a substantive right, and that's exactly what the second DCA said, that if you're looking at a policy contract, we're looking about between the rights of the insured and the insurer. Now you're getting into the contract as it
Coverage
affects.
is different because it's vested.
But in his hypothetical, the law says you can't pay out $500,000. What if the law said an insurance policy cannot include coverage for an earthquake that's over $500,000? Would you assume that applies to existing policies? That's the comparison here.
So yes, but in that case, you're affecting the rights as between these two parties to the contract. Here, this is someone who is well outside this contract that is enjoying a legislative created immunity.
Okay, we're going around and around on this. So you can have 30 seconds to finish up, and then you can have 2 minutes for rebuttal.
Okay. The way I see it from the way the Fourth set it up is an insurance contract, which is only between an insured and insurer, so sacrosanct that the Florida legislature is handcuffed from creating a reasonable immunity for an often abused third party to utilize to defend against subrogation suits that may or may not arise. Okay, we're talking about a third party who's not a party to this contract. Can they accept the benefits of what is an immunity statute? And the law protects vested rights, not theoretical possibilities. The law from SCOTUS to this court has been that a law is not retrospectively applied just because it changed prior expectations of the law. That tenet should not change just because it's an insurance company. Thank you.
Thanks.
Good morning, Your Honors. May it please the Court, Nancy Stamper for Universal. I'd like to start with the Pearsall case. I wasn't going to do this, but I think the Pearsall case lays the groundwork for where we are today. Pearsall has 3 different varieties. It says, first, there is a vested fixed right of future enjoyment. As far as Universal is concerned, its vested right of future enjoyment is if there's ever a time where we are obligated to pay you, Ms. Senko, insurance funds, then we have the right to subrogate. That's a vested right of future enjoyment.
That's not exactly what the insurance contract says. It's not a if then, it's if you have the right to recover, then we shall be subrogated to that
Correct.
right. So why, I mean, that language is still intact and can be applied without affecting the policy language at all. Only the nature of the right, which is extra contractual, has changed. So why is that a impairment of the contract?
Because she still has the right. She can still sue Grovile. She didn't lose her right. Only the insurance company lost its right.
No, that's what I'm saying. The insurance company still has the right of subrogation. So in other words, nothing about the contract has been, you could have this contract the day before and after the statute can be applied, under the language of the contract the exact same way, but now the nature of the right has changed. It doesn't say explicitly, we retain the right to sue your condo association. It's just if you have the right, then we get to exercise the right of subrogation. So why can't that be applied from a contractual standpoint the same before and after?
It is Universal's contractual right with Ms. Senko. There doesn't seem to be any case, I don't think either one of us found one that is in this context, which I think is why we're here today, because of the subrogation. But the right we bought was the right to sue. And we did that by adjusting
right
the
to
policy
sue if there's the right to sue.
if there's a right to sue.
Without any sort of limitation on
And there is still a right to sue.
a
They
date of
haven't-
when, a date of a right to recover and that sort of thing.
The right to recover still exists, but not for universal. And that's why our position is this affected the contract, the policy, and not the right to litigate. And I think if you go back to the Pearsall case, there were two other, RAM keeps coming up, RAM, Justice Kennedy, your case.
I've heard of that.
That's not this context. That
was an illegal contract.
That was an illegal contract. This is a legal contract. That is Pearsall's second category. Expectant depends on continued existence of present condition. That's a changed statute. I had a right under a statute, statute's gone. I have no further right, and I can't reach back to the statute because that was a matter of legislative grace. A contract is not a matter of legislative grace unless it's an illegal contract, and this is not an illegal contract. And the third category was contingent rights. They're contingent upon the existence of another event. Well, that's like the Raphael case. The third category that we deal with in these retroactive situations is tort law. Tort law, I have to vest my right. That's Raphael. The jury said, yes, you get your money. Then the legislature changed, and this court said, you don't change that vested right. That's a vested right. What we're talking about here.
Well, I mean, it's actually, the right's vested when the cause of action accrues in that context.
More accrued than right.
And you don't have to necessarily get a judgment. It's even more vested once you got a judgment, for sure. If you can think in terms of more vested, but it's. I think our law is that once a cause of action in that context, we're not talking about contracts, we're talking about the tort context. Once a cause of action accrues, then the legislature is restricted in what it can do to unsettle the rights that are associated with the already accrued cause of action.
And
correct?
That's the Raphael case, right?
Yes.
I personally think that the second DCA and Laguna got confused on what we bought with our policy. We bought a right. The right exists. The right still exists. We traded.
Or what you bargained for, because you didn't pay anything, but
we traded a premium. You get
right.
These premiums are set based on what you get and what I get.
So that's my question.
I'm sorry, Judge.
That was my question. Is this thing working? That was my question.
It's these, not that.
To you, Universal. They were able to charge the policyholder the cheaper premiums because they believe they could subrogate later, correct?
Correct.
So that's the right that I think we're talking about.
That
there was a bargain between the people who own condos. They would get this policy cheaper, but yet in the what they are able to subrogate later on from the wrongdoer.
Correct.
And that's basically going back to what Justice Kennedy mentioned earlier. The legislature messing with existing contracts. Universal would not have offered that policy had they known that later on they were not going to be able to collect.
They know better now, Judge. Policies changed. But you see, if the legislature had said, we're going to eliminate subrogation, we're going to eliminate no more subrogation. But an AOB is a subrogation contract. The subrogation still exists. It's a contract right. Had they eliminated the tort, I guess the tort would have been Ms. Senko's right to sue the association for the water damage. That would have been the tort that the legislature could have eliminated because they can do anything they want with tort law. But they didn't eliminate the tort. They didn't even eliminate the subrogation. They eliminated Universal's policy right, which it purchased. And I don't think...
your position is they actually didn't. They didn't do that because
they can't.
It's not intended to affect existing policies. They do it. They affect the policies you're going to issue in the future, but not
Prospectively, fine. Retrospectively, not under any case from this court.
But do you agree that this statute on its face only applies going forward? Or do you think because of the July 1st, 2010 and subsection 1 that is the effective date throughout each subsection?
It only applies going forward for two reasons. Number one, the intent of the statute on its face doesn't express any intention to retroactively apply it. But number two, we've combed the bills, we've all combed the bills, the legislative stuff. There's nothing that says the legislature intended this to apply retroactively. And that's the first of the two tests, the two-pronged test. Did the legislature intend? And the answer is no, and Grovile admitted that.
Don't to accept that argument, though, we have to have this July 1st, 2010 date confined to subsection 1.
I'm sorry, Judge?
Don't we need to accept that argument? Don't we need to say that the July 1st, 2010 date is confined to subsection 1? Or do you think it can go 2, 3, 4? Because
July 21st was the date of, I think, July 21st was the date.
Yes, I'm just talking about the language of the amended statute. So sub A says for policies issued or renewed on or after July 1st, 2010. And then it goes on to say that, it has to have this coverage unit, the maximum amount of any owner's unit loss assessment coverage, regardless of the number assessment. So in other words, it all seems to be requirements relating back to sub A with that
to
date.
The day that right.
So I think the issue is, do you think that the statute on its face can be interpreted in a way that says the legislature only meant to apply this? We don't even need to get into a retroactivity analysis. Or do you think that your argument depends on the kind of substantive right retroactivity analysis?
No, I think the legislative intent is clear on the date that this amendment was effective. Just as you said, it was effective as of, I thought it was July 21st, but maybe it was July 1st. But it can't relate backwards to my April 30th policy. It must relate forward.
I'm just asking whether the date in subsection 1 extends to 2, 3, and 4.
No, the date in subsection 1 has nothing to do. This subsection 4 has its own enacting legislation, and subsection 4 clearly says that and I think the 4th DCA addressed that also. In fact, I think the 2nd DCA said we're not applying a retroactivity analysis because it doesn't work. Those courts agreed that you can't retroactively affect this contract. The 4th said, and that's the end of the day. The 2nd said, no, we can move on and do something else. We can address the subrogation right. And I think where they got it wrong is, and I think Judge Arto did also, they focused on cases like Villa Maria that talk about the cause of action, and when the cause of action is perfected. That has nothing to do with what we're talking about here. We're talking about a prospective right. Universal may never have the right to subrogate, may never have, but it bought the right if they ever want to do it. You know what that's like? I may never bear arms, but I have the right to bear arms. And nothing can take that right away from me. That is a right I have now for a prospective enjoyment I may never use. The right to worship, the right to peaceably assemble. Those are prospective rights based on...
It's like the right of a policyholder under an insurance policy. You hope you're never going to have to make a claim.
You pray.
Okay, you pray you don't have to make a claim because therein lies difficulty frequently. But the right to make a claim and make a recovery for a covered loss is a very important contractual right, even though it hasn't accrued yet. But under that policy, that's what you've been paying those premiums for against the day that you might need it. And then they come along and say, oh, well, that policy we're going to do it, but because it hadn't accrued, we're going to be able to cut that off. That's a different, absent some really good reason. That's just not the way these things work. I know I'm just preaching to the choir here, but when you look at this language here,
I'm glad you are, Judge.
This language that the legislature passed says that, in these certain circumstances related to the condominiums policy, an insurance policy issued to an individual owner in the association may not provide rights of subrogation. It's talking about a limitation on the provisions of a policy. Now, how could they be talking about limitations on the provisions of a policy when the policies have already issued, as opposed to policies that are going to issue in the future after the effective date? Now, again, that's your argument, I know, but it just seems to jump out when we actually focus on this language here.
The legislature has retroactively rewritten our policy.
No, they haven't. That's his point.
But
is that they didn't.
If we were to accept opposing counsel's argument, it would result in that.
It seems like you're trying. I mean, I think you should win, okay? But you're making your case more complicated than the 4th DCA made it, and that it needs to be. I think what he's saying is that if you just read the statute in the most natural way, it doesn't even apply to this contract. So you don't even need to worry about which box to put the kind of right into and when it accrues and whatever. You only get into that whole complicated mess when you start with the premise that the legislature intended to take away whatever that thing was, and then you have to argue about how to categorize it and whatever. But if the legislature didn't disturb it in the first place, if the law does not govern this contract, then we don't, which is what the 4th DCA, that's what the majority's reasoning was. So it seems like that's the easiest claim.
I agree. I did not mean to overcomplicate it. Our first position is there is no legislative intent, and that is what we argued to the 4th District, and that's what we were successful with in the 4th and lost in the 2nd. And I think this is a pure contract construction retroactivity case, and this court has spoken on it at least a dozen times that I know of. So if Justice, and I'm sorry, Justice, I couldn't. I have hearing aids, but they don't work all that
That's
well.
fine. I might just have A instead of 1 too. It's fine.
Thank you. I respectfully request that you affirm the 4th DCA's and reverse the 2nd DCA's opinions. Thank you.
Thank you.
The cause of action actually existing because there is no right of subrogation without underlying loss. Until then, it is theoretical, it is contingent, it is inchoate. The Florida legislature has the right to prospectively change immunities, defenses, things going forward on a prospective basis.
But that's not what they did. They changed the policy. They're saying they're talking about, if what I read here, they're talking about what can be in a policy, that the policy may not provide rights of subrogation. It's directed at policy language.
Yes, I do understand that is the text, but in terms of here, this law, in a sense, it is future-looking, that it is telling between unit owners and association master policies, this is how it's going to play out. But here, it is being prospectively applied because it's not attacking subrogation rights that were in a prior policy. Okay, it just isn't. It's not changing any of it. It is still saying, okay, it's there, but are we applying this prospectively? And we can't do that without having a fully mature, ripened cause of action.
Well, but your position requires, basically your position says that because of this legislation, in this existing policy, you got to line out that you get the part there, you get the 2 different provisions. You got to line out the provision having to do with subrogation. And I don't see any other way you read what the legislature, the way you understand what the legislature has done. Now, I think that's not the way we typically would view that.
I understand what you're reading, but it only applies to associations. A subrogation contract is still whole in there, and there are so many other categories of people that they can go after to recoup 10, 20 cents. But the legislature here is prospectively.
Well, so you wouldn't be lining it out except for claims against the condo association. You'd actually be adding words into it as opposed to lining it out.
One of our former colleagues would have called it something like a Faber College codicil. Okay, you can have 30 seconds to finish up.
Okay. in order for Universal to overcome this presumption of prospective, I just want you to see what it has had to do, okay? It's had to ask this court to ignore longstanding Florida case law requiring an examination as to whether we're speaking of a vested right. It has had to bootstrap its subrogated cause of action starting after the statutory date back to its antecedent policy date, and then it has had to foist its substantive rights as the second DCA, which exists only as it's bargained for between itself and its insured, onto third parties outside of the contract. We would ask this court to follow all of the case law, and we understand that this is a dicey area. We're just going to say that, but we expect you to follow the same case law that you have had all along and apply it here. And in this case, we would ask that this court would approve the Laguna Rivera decision and quash the 4th District.
Thank you very much. We're adjourned.
All rise.